and Mr. Slicker. Good morning, gentlemen. And Mr. Sullivan, I'm going to ask you to unmute your microphone when we're ready to proceed with the argument. And if I may, Mr. Sullivan, I realize that you're here representing yourself, and I will take a minute to kind of explain how we handle cases here on the appellate court. We run kind of a formal hearing, and when I say formal hearing, that means each side, you've heard me say, is given 20 minutes to make their argument. Unlike TV where people interrupt each other and object, we don't handle that here. So you'll have your full 20 minutes, and then if you wish, you could tell me, Judge, I'd like to reserve 5 minutes for rebuttal. That way you could proceed with 15 minutes, and when Mr. Slicker makes his argument, you could then come back and you have 5 extra minutes. So with that, Mr. Sullivan, are you ready to proceed, sir?
Yes, ma'am.
Very good. You may proceed.
I'd like to first thank you, this honorable second appellate court, for this opportunity to advocate after the best time. I'm pro se. I represent myself. I'm not a lawyer. I'm an occupational therapist. What I'm requesting is for the final judgment to be reprimanded and voided with a new venue for trial. The issues, its ultimate decision-making authority was granted to the appellee based upon no facts or relevant data or expert testimony to justify it, and there's nothing documented in the entire final judgment to justify anything where they got any of the information. And I know in the second and third hand hearsay, proven false by every expert trial, but I've seen, I think, 16 case logs by every appellate court that shared parental responsibility can't coexist with final decision-making authority, because the other parent will trump over every single decision, even if it's against the best interest of the child under 61.13. That's exactly what has happened in this situation. The other area that I'm asking for relief upon is, just as the reply brief that Attorney Slicker has written, there's absolutely no validation, support, evidence, transcripts. Every expert and professional witness, and I don't have a lot of money, but I was able to get every one of them into the appellate record. There was no references to anything, just like the final judgment. And that's disturbing, because when we're looking at a child, and that's what this whole argument is for, the child, not for me, not for the lawyers, not for the judges, but for the child. When we look at the child and we look at what is put upon him in public display against privacy law, and we look at the orders of this lower court to give this final judgment to every single medical facility, educational institution, it was given to the IRS, it was given to DCF, it's been given to everyone. Court order. Now, I would accept it if it was true, but it's not true. And when you have on record number 2522 through 2593, you have the appellee admitting and confessing that she committed contempt of court, went alone to 7 different professionals. Both judges on this case, the disqualified judge and the second judge, were aware of this. In fact, Judge Jack Hellinger found the mom not in contempt for what she admitted to a year later of committing contempt. So she went alone, got these reports, misrepresented the child's conditions, took it to the school IEP under the rule of sequestration ordered by the judge, went to the very witness at the autism department in the school, created evidence, put all these falsified reports into the IEP meeting. They gave those to other witnesses, to the judges, and they used it for the final judgment. Unbelievable. And the judge, Jack Hellinger, was completely aware of this beforehand and during and afterwards. So, it's one thing when it can go either way with broad view of discretion. It's another thing when you have corroborated evidence from 20 witnesses of the past and a continuation of final hearing, the 4 new witnesses of the present, and then the mom confesses under admission that she did commit contempt of court. She did go alone against court order, and she misrepresented the child. Now, those reports, when I found out, were deemed invalid because when in subjective interview, you have to tell the truth to the doctors. If you don't, then they make the wrong interventions. The child's treated and billed for conditions he doesn't have. The school puts the child in the most restrictive environment against the law. That's against civil rights law. In fact, the least restrictive environment is the single most important civil rights law in the United States for children. It doesn't matter what your conditions are. He was forced into a 100% autistic classroom. And that's exactly what happened. This was used in trial. Judge Jack Ellinger, he clearly knew all of this. And another thing that they did, they didn't allow the guardian ad litem to come back on the case for 2 years or any new guardian ad litem. It's unprecedented in comparison to every other case in the state of Florida. 5 out of the 5 court-appointed witnesses that are experts testified that the father should be the ultimate decision-making authority, not the mother. And that's really important because both judges and Attorney Slicker have never seen this child. I am arguing because, not just because I love this child, but because he deserves justice. You see, all of this is about a trial within a trial. You know, I know we're scratching our heads. Well, why would judges do this? Why wouldn't they order a guardian ad litem on the case? Why wouldn't they have the diagnostic testing that was court stipulated? I mean, parental stipulated, court approved. The diagnostic testing of this child, which is another one of my requests, is because one of my issues of appeal has requested. This boy is now 11. I love kids. I work with kids. I love them. But when you have a rap sheet that's false, whether it's criminal or false disabilities and conditions, it could be detrimental to the ultimate level forever for this kid. Not only that, is every person that has to read this final judgment of misrepresentation will have to go by what is written in that. You see, fraud is very important to how it happened in this case. I already explained what was allowed in contempt of court by the judges. They allowed this to happen. And after the confessions, they could have corrected this error. But it wasn't a legal error by mistake. Even Tom Brady has a bad day and can lose a Super Bowl. Great judges can have a bad day. This was deliberate with intent on the second judge, not the first judge. The first judge was misled by misinformation by Attorney William Slicker and the community law program. And this became about complaints, proving the complaints is false in the best interest of this child under 61.13, under the rules and laws of procedure, was obstructed to the ultimate level. Now, it's unfortunate because the community law program, which is inside the courthouse venue, I filed a complaint on them because they were trying to build tons of money. And they were doing that to everybody, not just me. I wasn't the only victim. Now, they referred that to the Florida Bar and Attorney Slicker, who's the president of the law program. Both judges are completely aware of this program. Judge Jack Ellinger is a founding part of this program. And this created a severe conflict of interest because they had to prove that complaint is false. And they took those complaints to the judges. The CEO of the community law program, Kimberly Rogers, is in the transcript, testified in the trial, and they awarded money to them. It's amazing, the conflict of interest. Judge Jack Ellinger, he started that program with Attorney William Slicker. Now, this is a conflict of interest, and this is the reason why my initial attorney for 2 years, Carlos Ramirez, gave up. He said, I'm going to save you money because you can't win there. You have to get out of that venue. And that's why I filed for a transfer of venue. Judge Peter Ransberger talked about this case. It's on the transcript. I referenced it in my brief to all the other judges in family law. Now, that is a very bad thing because he was wrong. He was wrong in his judgment. This is the problem when we presume on a false narrative. How it happened, it's really not a reason, but it did happen. And when you have a great judge, and I still say I love Judge Peter Ransberger. He's one of the best judges in District 6. But he was unfortunately influenced by the machinery of fraud by attorneys like in a law firm. And the school had their own personal interests as well. They billed 6 figures in federal insurance on autism on this boy. They put him in a 100% autistic classroom when he's not autistic. He's never been diagnosed with autism. So you can see the conflicts of interest. So when Judge Peter Ransberger disqualified himself after allowing the renaming of a partial final judgment at the end of the second day of trial with 24 witnesses testifying, including myself, with one witness left in the entire trial, the mother, wow, we waited 8 months to have the continuation just to give Mr. Slicker and his client more time to do what they have to do. They should have had that done all over with. Then Judge Peter Ransberger apparently got a lot of ex parte information about incorrect, falsified information. And he ordered my lawyer off the case in a trial hearing. I said, please, I owe him a little bit of money. I'll get on a payment plan. I only make $72,000 a year. Please give me a chance. And he said, no, you're going to stand trial alone. You can handle it yourself. We got a trial in 5 weeks, one more day. And that's what happened. I didn't choose to be pro se. I never was pro se before my lawyer was court ordered off the case. I was ordered pro se. And that was terrible. But I did recuse the first judge only for the reason to get to Tampa, Florida, which is the same distance. I knew, and my lawyer was right, Mr. Ramirez, if I don't get out of that courthouse venue, it doesn't matter how many lawyers I have, I'm going to lose. This is a pre-decided case to prove the complaints against the school and the community law program in the Florida bar as false. And now we throw in the recusal of Judge Peter Ransberger. And we see in the August 3rd, 2017 hearing just what Judge Jack Ellinger is going to do to me and my son and every expert witness. I mean, when you really think about it, when you look at every expert and professional witness, which is all on court file and transcript certified, they all testified opposite what was written in the final judgment of no references. Think about that. So is that perjury? I don't know. I'm not trying to say that they did something wrong, but it's not right. It's very injustice. And by not allowing a guardian ad litem back on the case for well over 2.5 years, with no updates on this case, and the child continues to develop upwards, why didn't they want a guardian ad litem? Because they didn't want an independent report to investigate all the fraud that's going on, all the contempt, what's going on in school, going to the experts to see the truth with an independent report that would contraindicate what they're doing, the obstruction and what they're doing. I can't explain what happened in this case is so unprecedented in comparison to any other case. I mean, it was a nonstop manifesto of doing what they had to do to prove their complaints is false. And that is the cause and reason of what happened in this case. But they forgot about the child. We all have children, or we know children, or we love children. You can't fake all types of things on a child, put them through all types of containment and discrimination, not give him what he needs as a not just as a parent, but as a court. The judge and officers of the court are not the court. The court is the court. And they were separate from the court in this case. Maybe they're great on every other case. I'm not saying, I've never said that they're not. I'm not saying that Judge Jack Hellinger is a bad judge. I'm sure he's a very good judge in most cases. But in this case, he let the machinery of fraud taint the court so they could not function in a fair, impartial capacity. And that's exactly what happened here. Everything that I have done, and I have sacrificed and went through so much suffering, is for the best interest of the child. I make a living. I'm not doing this for money. I'm not doing this for me. You know, yes, the experts, they all can't believe what happened. Nobody will go up against Jack Hellinger. He is the most powerful judge in District 6. He said it on record that nobody's above him, not even the chief judge. And I'm terrified. I didn't even file a motion to stay because he's going to retaliate against me like he already attempted so many times to put me in jail for nothing. I mean, he ordered the mental therapist, Andrea Mason, after he canceled the guardian ad litem. He canceled the diagnostic testing of the child because the testing results would corroborate the 2015 court order testing that was testified by the experts. He doesn't have any autism. And that would have sealed the deal and it ruled out all the evidence of Mr. Slicker that nobody testified upon. That's why he doesn't reference his evidence in any of his reply brief, in any of the final judgment, that he was privileged. When I was ordered pro se, he wrote the first 5 pages of the final judgment. Then they inserted it in the 21 points of family law. That's a fact. That's not hearsay. That's not hearsay like the final judgment or the reply brief. All that they did was a complete fraud. Now, I have to say that I wish this didn't happen. I wish that, how many times that I requested for a settlement. Now, I can't believe that Judge Peter Ransberger believed what was told to him on an ex parte level. He's on record against Florida ethical canon talking about the case to the other judges when he was wrong on the case. He was completely wrong. And that influenced and biased the other judges, including Jack Hellinger, who got involved before he took it from the random selection in violation of docket rule 1.03 and took the case from Amy Williams. Now, that's crazy. I love Amy Williams. I've heard nothing but glorified things. She would have put a guardian litem in the case. She would allow the diagnostic testing to be completed for the best interest of the child.
And Mr. Sullivan, I appreciate, I'm looking at the clock. I want to give you at least 5 minutes to be able to rebut what Mr. Slicker is indicating. So if at this time, would you like to kind of hold, do you want to finish your thought, or do you want to save the rest for rebuttal?
Oh, yes. I like to save the rest for rebuttal.
Very good. Thank you, Mr. Sullivan. I appreciate it. So at this time, Mr. Sullivan, I'm going to trouble you to please mute your microphone, and I'm going to ask Mr. Slicker to unmute his so he could proceed with his argument. Very good. Mr. Slicker, whenever you're ready. Very good, Mr. Slicker. Excellent. All right, you may proceed, sir.
Vassachest, Your Honors, I'm William Slicker for counsel for the mother. Going to divide my argument into basically thirds: procedure, facts, law. This is a paternity case about what is the best parental responsibility and time sharing for the party's minor child. At the time of trial, the party's minor child was an 8-year-old boy with special needs. At the time of trial, the parties had been in litigation for almost 4 years. The reason that the case had dragged on for that long is because the father kept finding reasons to delay the case. He went through 5 different attorneys, and each time he changed attorneys, it caused a delay. He recused the first judge, Judge Ransberger himself, who has a special needs child. He recused him. That caused a delay. That was done after we already had 2 days of trial. He also caused a delay. In between attorneys, he represented himself. When he represented himself, he filed approximately 30 different motions. When his motions were denied, he would file for rehearing. When the rehearings were denied, he sometimes filed appeals. All of that took time. At one point, he said he would pay for providing the transcript of the first 2 days of trial for the second judge to read, but after several months, he still had not done so. I paid for the transcript to be done, but that also caused a delay. One has to wonder why he was causing so many delays, if perhaps he was afraid that what he knew of the trial was going to be. However, we got to the outcome finally. The judge made his ruling, and Mr. Sullivan appealed that. It's now been about 2 years since that happened. Again, Mr. Sullivan has found ways to delay a decision. He got 7 extensions on his initial brief, 5 extensions on his reply brief. Now the child is 10 years old, and the parties have been in litigation for about 6 of those years. Luckily, since the time of the final judgment, at least the child the things have settled down. The child's been doing well in school. At the end of the year, he had A's and B's, and most of his classes, he had a C in math. Going into trial, the mother was seeking sole parental responsibility, and the father was seeking shared parental responsibility with final decision-making authority. What the judge ordered was that the parties have shared parental responsibility, with the mother having final decision-making authority of both the health, psychological decisions, and the schooling of the minor child. The mother was given approximately 70% of the overnights, the father approximately 30% of the overnights, and the court set child support based on guideline statute. Turning to the facts, originally when I got in the case, I thought it was an issue as to whether the party's son was on the autism spectrum or whether he had ADHD or both, and what was the best treatment for him. However, after reviewing all of the reports, listening to all of the witnesses, the child probably has what used to be called Asperger's, which is on the high end of the spectrum, and he is probably dual diagnosed as ADHD. Dr. Kravitz, a doctor at Johns Hopkins All Children's Hospital in St. Petersburg, diagnosed the child as autistic, as did Dr. Casadante, as did the child's own pediatrician, Dr. Vaughn. The father did have a medical expert, Dr. Karnaskis, who had diagnosed the child as being ADHD, but who admitted that if another expert diagnosed the child, they would probably diagnose him as Asperger's. Father never called that expert to trial. Everybody at least has admitted that the child has a sensory processing disorder. Based on the child's sensory processing disorder and his diagnosis, he was in a special needs class at the time of trial that was specifically contoured to meet his particular needs, and he was doing well in that class. As long as he was dual diagnosed, he received speech therapy and was on a consultant basis for occupational therapy that was beneficial to him and was covered by health insurance. If the child had been diagnosed with ADHD, then those therapies would not have been covered. At the time of trial, the person who had been there for the son was the mother. She's the one who had cared for the child through the difficult formative years, diaper changes, caring for a child with special needs who has a limited ability to voice his needs, while the father was off gambling and working. Mom is the one who is primary caregiver, had adjusted her life to meet the needs of the special needs child. She's the one who had listened to the OT therapist from the school and had placed charts in the home to help the child. She's the one who tried to maintain a set schedule for the child. She's the one who tried to give him the recommended stimulus without overstimulating him. She's the one who went to school to have input into the IEP meetings and to volunteer in the child's class. She's the one who paid attention to the child's sensory diet. And by sensory diet, that's tactile, not food diet, although she did that as well. On the other hand, the dad had a need to be in control. The mother had left the dad because of abuse issues. The father was still trying to control the mother through control, such as when he made his child support payments, making her beg to get those payments. He was controlling as to when he dropped off and picked up the child, even though there was a court order that set the time for that. He refused to have let the mother have visitation on Mother's Day or on the mother's birthday. Father did not think he had to obey court orders. He did not comply with the court order that set drop-off and pickup times. He did not comply with the court order to pay child support on the first of the month. He did not comply with the court order to pay child by direct deposit. He did not comply with the court order to unilaterally stop taking the child for evaluations without the consent of the mother. Despite being held in contempt of court for not producing all of his records by the time of trial, he still had not provided all of his records. In fact, the father told the mother he did not have to comply with court orders, and his actions reflect that attitude. The father was devious. Rather than deposit his income from his checks into any of his businesses, he cashed them at Amscot to the tune of about $175,000 over 2.5 years. He was regularly at the Seminole Casino in Tampa, where over a period of just over 2 years, he gambled $1,740,000 and lost $162,000. So paying child support was putting a crimp in his gambling. The Seminole Casino only captured those times when he used his player's card His bank statements show there were other times he was at the Seminole Casino where he gambled without using his player's card. In his deposition, he said he wasn't even at the casino during those times, but the casino records and the bank records showed otherwise. In addition to gambling at the casino, he regularly played internet poker, online fantasy football, and the Florida lottery. Someone with access to the mother's social security number and her fiance's social security number got access to the mother's Department of Children and Family records and made changes to them. Also gained access to the mother's health records for her minor daughter, made changes to those. The only person other than the mother and her fiance who had both of those numbers was Mr. Sullivan. The father had forged the mother's signature on documents. He had sent emails to non-existent email addresses to make it appear that he had given notice to the mother, when in fact he had not given her notice. Unfortunately, in an effort to show that the party's child was not on the autism spectrum, the father forced the party's child to repeat tasks multiple times while he videotaped the child performed the task to a standard the father thought appropriate, so that he could show that take to the evaluators in an effort to show that the child was not on the autism spectrum. At trial, the court saw one of the outtakes where the child had performed a task not up to the standard the father wanted, and the father had yelled at the child, "Now we got to do it all over again." And the child cried. While with the dad, the child stayed up late, ate pizza for breakfast, and lived an unregimented life. The child would return home to the mother, tired, hungry, dirty, and being continuously videotaped. I came to believe that the issue in this case was not really about whether the child was on the autism spectrum or both, because the child was receiving the therapy that he needed and the classes that he needed. I came to believe that the reason the parties had engaged in such lengthy litigation was that the father still wanted to control the mother, and he did not want to pay child support because he needed his money to pay for his gambling habit. Trial court clearly made the right decision, placing the party's child with the mother, his sister, and the mother's fiance, who also has Asperger's, because they were the true nurturing family for this boy. Turning to the law, the trial court's decision comes to the appellate court with a presumption of correctness, and the burden is on the appellant to demonstrate error. The standard for review in family law cases is whether there's been an abuse of discretion by the trial court. If the decision of the trial court is not unreasonable, then there is no discretion. That, of course, is from Canacris versus Canacris. It is the duty of the appellant to provide a sufficient record to the appellate court. That, of course, is the Applegate versus Barnett Bank case, which has also been cited by this court in its recent case of Jacobs versus Jaquez, also cited by this court in Frenza versus Frenza and Eshaw versus Eshaw. The appellant proceeds without a full transcript. They do so at their own peril. Erlinger versus Federico. Without a complete record, the appellate court is unable to resolve factual issues and therefore cannot conclude that the trial court's judgment was not supported by the evidence. That's Cordovas versus Cordovas and Starks versus Starks. Without a full transcript, the appellate court must affirm. That's Stein versus Charles. In the case at hand, the appellant failed to provide a complete transcript of the trial. The appellant cherry-picked the best portions of 3 out of over 20 witnesses and sent them up as if they were the entire record on appeal. My client's a stay-at-home mother who's been declared indigent. Therefore, she could not afford to send up the entire record on appeal. And as you know, court reporters do not transcript unless they're paid, even if a party is declared indigent. So she could not get the court reporters to transcribe. Also, under the current law, the mother could not force the appellant to provide a full transcript. That's the Fay versus Craig case out of the 5th DCA 2012. In addition, in the case at hand, the appellant filed some documents after the final hearing and sent them up as if they were part of the record on appeal, which they really were not. Accordingly, this court should simply affirm on the basis that 1, the appellant has not sent up the entire record. 2, those portions sent up actually support the trial court's ruling. Court wanted to, it could go further and admonish the appellant for filing documents after the ruling was made and sending them up, and in so doing so, trying to mislead this court as to what the full record on appeal is. In addition, this morning, Sullivan delivered to my office, so apparently he's delivered it to you too, some other further document in which he accuses Judge Hellinger of trying to lead all the witnesses, and that he bullied by tyranny and intimidation, indirect blackmail, extortion, allowed fraud as evidence to tamper witnesses. Throughout this thing, Mr. Sullivan has accused Judge Ramsberger, Judge Hellinger, myself, the president of the community law program, all of being in some kind of big fraudulent conspiracy. In fact, Mr. Sullivan said in his motions to transfer venue over to Hillsborough that he couldn't get a fair hearing in front of any judge in the Sixth Circuit because they were all in cahoots with each other. So probably when this is all over, if this court affirms, you all will probably be added into the big conspiracy. Thank you.
Thank you, Mr. Slicker. Can I trouble you to mute your microphone now? And Mr. Sullivan, you do have 5 minutes for rebuttal, sir. Okay, go ahead.
Okay. Yeah, the only thing that Mr. Slicker stated during his argument that's true and backed up by transcript or evidence is that he tried to justify that fraud is allowed in order for the town to get services for conditions. Everything that Mr. Slicker said as a lay witness, or as a lay officer before expert matters, is considered hearsay. And that's what they use, is hearsay for the entire final judgment. That's wrong. And this was all proven false hearsay later on. And both judges made the mistake, the error, by making decisions and presumptions on procedure before the evidence was in, before the witnesses testified. And I can't imagine what Judge Ransberger would have done if he got to see the mom's testimony, or Dr. Fine, which Mr. Slicker told the bailiff to send home when she was subpoenaed to testify on the second day of trial. We see what she said in her. These are court-appointed experts for the child, not for the father. Not for the father, they're for the child. And they all testified in corroborated and conclusive findings on everything I stated in my initial brief and my reply brief. 100% backed up by fact. This is a court of fact and law and procedure. All were violated. Now, when you look at the final judgment and the reply brief that Mr. Slicker wrote, they're identical. They're identical with no references to anything that they wrote in there on expert matters. I have written, and you will see in the supplement that Mr. Slicker refused to summarize the remaining 4 lay witnesses. He refused to pay for the transcripts. He had the same amount of time to provide evidence. In fact, he was told to correct the record on his initial reply brief because he just puts in parts of records and he lies. He falsifies information. Now, I hate to say that, but that's the truth. I wish that it wasn't that way, but and father, yes, he ran out of money with two of his lawyers. The other lawyer moved. So what? He had a couple of lawyers. This has been going on for half of a decade because he could not win. Mr. Slicker could not win by the rule of law, by facts, by experts. So they obstructed everything. The outcome of this entire trial would have been different if it was in Tampa or done by Amy Williams, or if there was a guardian ad litem back on the case, or the testing would have been done by the child. You see, this obstruction of evidence that never happened by the judge affected the whole outcome of the trial. Not to mention that they allowed contempt of court knowingly and with intent to mislead the appellate court. How can they plan for a Novero appeal in the middle of the trial? And the judge referenced the appeal 5 times. He stared down the father laughing, Judge Jack Hellinger. How could he do that in the middle of the trial? They planned for a Novero. That's why they obstructed the last 2 days of the trial transcripts from the record. They gave the full transcripts to the father in March of 2019. So I didn't have it. I had the condensed version. You see what they did? They obstructed all types of evidence, and that's just one of 100 things that they did. It's all in my brief. The case law to support what they did is in my brief. But when the machinery of fraud affects the ability for the court to act in a fair and impartial manner, that's why I asked for a transfer to Tampa. And Judge Peter Ransberger would have granted it. He just couldn't remember to talk about the entire case and show the evidence to the other judges. I showed him the transcript. He said it's too late. The next judge will decide that. And Amy Williams was that judge. She was on the docket for 27 days, and Judge Jack Hellinger deliberately, with intent, took the case from her and executed and acted as a prosecutor. Trying to, you see the transcript. He's trying to lead every witness what to say in the pre-written final judgment. It's awful. It's awful. And he actually admitted he didn't even read the first 2 days of the trial transcript. He told Michael Lorberg, my lawyer, who said, you can't win here. You filed complaints. This is about the complaints, not about your child or you or anybody else. They're coming after you. I'm out of here. And that was it. That was the end of the trial. Cross-examination of the mother was stopped in the middle of it. We had depositions where she lied on 72 things on her depositions. Judge Jack Hellinger stopped the whole cross-examination. We're out of time. And didn't allow me for rebuttal, didn't allow me to testify in my volume for evidence. But there was an order for all evidence to be thrown into the record bin. So that's why Mr. Slicker used it, even though nobody testified upon it, even though it was illegally obtained and inadmissible, no pre-trial sharing of evidence. And this evidence was also given to Andrea Mason. In fact,
And if I could interrupt you, Mr. Sullivan, I have the little timer here, and it looks like you basically have used up all of your rebuttal time. Okay.
the only thing also can I ask is that attorney costs be considered under the American rule, because the means to pay principle was self-created, just like the record argument, and that I be reimbursed the $5,000 I would have to pay Mr. Slicker, and that child support we calculated on what I make at $72,000 a year. Versus I'm paying almost $2,000 a month to them, and it's based upon speculation and what I made 7 years ago. And I'm done, Your Honor.
All right. Well, thank you, Mr. Sullivan. Thank you, Mr. Slicker. And if I could trouble you, Mr. Sullivan, at this time, if you all, because we're ready to call in the next case, and I think if you could just, I think you remove yourselves to a different room from